Ms. Long,
Yes, Your Honor.
you may proceed.
May it please the court. Emily Long, on behalf of respondent Christopher Ross Jr., I'd ask for 3 minutes to be reserved for rebuttal. Christopher principally comes before the court seeking a new trial. In 2014, the then 15-year-old Christopher's relationship with the complainant had slowly progressed from a friendship into sexting. In November of 2014, around 4 p.m., that relationship became physical in a high school hallway. Interrupted by a teacher, the encounter ended with Christopher using the complainant's phone to call his mother. 1 week later, Christopher Ross was arrested, and his mother received a phone call that her son was being investigated for rape. Starkly different stories emerged. The complainant said that she was violently assaulted, that the assault did not end until she struck Christopher, running away, and was home within minutes. Christopher said, on the other hand, that the encounter was consensual, that he had used her phone afterwards, and far from running away, she remained at the school and he saw her nearly an hour later. 3 months later and 5 months before trial, Christopher and his mother hired trial counsel for the CSC4 charge that was levied against him. In their first meeting, Christopher and his mother told counsel that the complainant was not being truthful, that the encounter was consensual and was precipitated by months of social media contact and sexting. They told him that a number of witnesses were present during and around the time of the alleged assault, and that the sexual encounter ended not with being struck and having the complainant run away, but by Christopher borrowing her phone. Armed with that information, defense counsel did exactly nothing. He did not interview witnesses and therefore did not recognize that witnesses Ariel Crooms and Trevor Muir could establish a timeline making the complainant's allegation at best improbable, if not impossible. He never learned that Christopher's mother spoke to the complainant in the minutes after the alleged sexual assault. He did not issue any subpoenas to social media. He did not secure an expert. He did not make any effort to secure the phone records, which should have been the foundation of the defense strategy. He waived to bench trial. The prosecution's case hinged on credibility, and despite a wealth of impeachment evidence available to him, counsel discovered none of it. Applying the Strickland standard with the guidance of this court's decisions in Armstrong, Trachtenberg, and Ackley, Christopher received ineffective assistance of counsel and is entitled to a new trial. I also come before the court. We seek guidance on the important questions posed by this court that fundamentally address broad issues of access to justice and due process of law. This young man has spent years defending the charge of criminal sexual conduct, being prosecuted by the state while subject to incarceration. As a juvenile, he should at a minimum have the same access to justice as similarly situated adults relative to appellate deadlines and standards for new trial. Despite a contentious and lengthy Ginther hearing, where Christopher alleged multiple points of error and heavily disputed the scope of that hearing, the trier of fact ultimately concluded that defense counsel's failure to secure the phone records proving the complainant's lie rendered her verdict against Christopher infirm. The Court of Appeals reversed, improperly shifting the investigatory burden from counsel to the 15-year-old client and his mother. The opinion failed to acknowledge that an impeachment case is not simply built upon saying that the complainant is not telling the truth, but showing the trier of fact that her word was untrustworthy. The court erred by failing to apply this court's holdings, setting forth that it is ineffective to not investigate, that a sound strategy cannot follow an incomplete investigation, and that when a prosecution hinges on credibility, it is ineffective to not build an impeachment case and to not utilize the evidence corroborating the defendant's version of events.
Ms. Long, I'm going to interrupt you and see what questions my colleagues have. If there aren't any, we'll be able to get back to anything you want to make sure we have heard, okay?
Thank you, Chief Justice.
Starting with Justice Viviano.
I'm going to pass for now. Thank you.
Justice Bernstein.
Good morning, counsel. I'm going to pass for now, but thank you.
Justice Clement.
Great, thank you. So there's definitely confusion within the bar regarding the timeline for filing an application for leave to appeal in juvenile delinquency matters. If our court decides that your application in this court was untimely, tell us why we should still consider the application.
Thank you, Justice. For the reasons that are set forth in the amicus brief, I think that far wiser appellate minds than I have been asked to weigh in on this issue. And I'm a practitioner who is down trying to decide these issues at the trial level. And with the learned counsel who were not able to come to a fast and easy decision about whether or not this constitutes a criminal or a civil filing deadline, I'd ask that the rule of lenity apply here and that any ambiguity go to my client. Certainly the implications are significant, and it's well briefed that the criminal implications or the criminal process here is invoked by the prosecution in almost every other respect of this case, except as it relates to that appellate deadline. It looks like a criminal trial. It acts like a criminal trial. He's charged with a crime, and in fact, he is subject to incarceration. And for all of those reasons, I think it is reasonable, given the ambiguity in the rule, for counsel to choose the criminal filing deadline. And again, if this court were to find otherwise, I'd ask that that not go to the detriment of Mr. Ross.
Thank you. How do you respond to the prosecutor's argument that your client's credibility was so badly damaged by his inconsistent statements to police and the other act's evidence that the trial court would have found him an incredible witness, even if the phone records had been admitted?
Well, I would answer that question first by saying that the trial court herself had the opportunity to weigh in on this issue, and she herself said that this would have changed her mind. So unlike another situation where we might be trying to peer into the mind of jurors, we actually have the trier of fact saying that this piece of evidence alone was significant enough to bolster and corroborate the credibility of Christopher Ross and to impugn the credibility of the complainant. And I think that this situation is not so dissimilar to that the court was faced with perhaps in Armstrong, or in which case there were a lot of contacts that defense counsel might have rightfully been concerned about, the relationship with a 15-year-old girl in that particular case. But the fact of the matter is that Christopher Ross was telling the truth about a key matter that the trial court herself, if you look at the opinion that she read into the record, she said, you convicted yourself. Your explanation relative to this phone call that a 15 or 16-year-old boy would break off a sexual encounter because he needed to call his mother was so incredible to the trial court that she said, you convicted yourself. And then she later learned that he, in fact, was telling the truth, and it was the complainant who lied.
Thank you, Ms. Long.
Justice Kavanaugh?
My question is directed towards the second issue that we asked to be briefed on supplemental briefing on what is the standard governing a new trial. And I guess I'd like to hear your position. I mean, I've read your brief, obviously, but am I correct? I'm reading MCR 3.992A, and particularly the sentence that says a motion will not be considered unless it presents a matter not previously presented to the court or presented but not previously considered by the court, which, if true, would cause the court to reconsider the case. Is that a standard governing whether or not a new trial should be granted, or is that more akin to sort of a gatekeeping function of whether or not the motion for new trial can be filed? And the standard then is found in 3.902, which references 2.613, which is basically akin to 6.431, all those numbers.
Yes, Justice. If I understand your question correctly, my position is that, and this is what was invoked initially at the trial court level in this particular case, that 3.992A is in fact the standard, because the trial court in this case initially rejected Mr. Randazzo's motion, the first motion for new trial, wherein he said, I have these records, you should have heard these records, it was error not to admit these records. And on the record, Judge Brennan addressed the standard for new trial, having indicated that Mr. Randazzo had brought that already to the court's attention, and therefore it had been previously considered. My second motion for new trial was rejected in large measure on the same basis, that these were matters that had previously been presented to the court. And so I do believe that based upon, especially the application in this case, at best there is confusion, but in this case, 3.992A was treated as the standard.
Okay, and is it your position that that was the proper standard to be looking at that under, or should we be looking at the others?
I believe that we should be looking at the others. I believe that the mechanism that says that if this has not been previously brought to the court, in a circumstance exactly such as this, where there is an objection at trial that's levied, and rather than being able to flush out the objection in a motion for a new trial, in this particular case, the application of that standard was to prevent the, ostensibly saying it was an inappropriately laid motion for a new trial.
Okay, thank you.
Thank you.
Justice Markman?
No further questions. Thank you.
Justice Zara?
No questions at this time. Thank you.
Did I already go to you, Justice Viviano? Justice Viviano?
You did. You did. Thank you.
Okay. Circling back. Do you have any questions now? Nope. Okay. You may reserve the rest of your time for rebuttal.
Thank you, Chief Justice.
Ms. Walton.
Madam Chief Justice, fellow justices, may it please the court, Assistant Prosecutor Danielle Walton from the Oakland County Prosecutor's Office, representing the petitioner appellee, the people of the state of Michigan. A number of years ago, former Justice Young came and spoke to practitioners, and he indicated that there's a flaw that he'd seen in practitioners' arguments, and that is many times that they make a straightforward proposition too complicated. And here, when the question is whether juvenile delinquency proceedings are criminal or civil, and we have a statute which specifically states that unless otherwise specified, these provisions are not criminal, which box do you check? Criminal or civil? Civil. And when, at the time the application was filed in this case, this court's court rule in MCR 7.212 specifically categorized non-criminal juvenile delinquency proceedings as civil. Which standard do you apply? Civil. And when you pull up the docket entries in this case, in the first docket entry that we see is a claim of appeal civil, which box would it be prudent to check? Civil. Now, amici in this case that are aligned with respondent are result-oriented in this case because it is detrimental to juveniles to categorize these proceedings as criminal. And both amici and respondent are arguing for better representation for juveniles, which would include being aware of the non-criminal label for these proceedings. Respondents retained counsel did not timely file the application and the application be dismissed. And this court indicates in its IOPs that deadlines are strictly enforced. That means for both parties. However, if this court declines to dismiss the case and proceeds to the issue of what's the proper standard to apply in this case, that is the standard articulated by Strickland versus Washington for 4 primary reasons. First of all, because respondent has waived the claim that any other standard would apply in the family court, in the Court of Appeals, and in the Supreme Court. And secondly, the standard in Strickland is consistent with this court standard in MCR 3.902, which refers to MCR 2.613, which addresses when purported party error entitles a respondent to a new trial. Third, Strickland is consistent with the requirements of due process because Strickland itself was geared to address fundamental fairness, which is the same standard for the due process clause. And almost every state that has addressed the issue of what is the test for ineffective assistance of counsel for juveniles has applied Strickland. And a number of states, it's particularly the juvenile that has wanted the court to apply Strickland. Why? Because the past history of the due process clause, both generally in the family court, has been less protective than the Sixth Amendment. And this court, and the Court of Appeals did not clearly err in the application of Strickland in this case. This court is not an error-correcting court, and here respondents failed to show that the Court of Appeals clearly erred in finding that respondents' counsel acted strategically concerning his investigation. So we ask in this case that this court either dismiss or deny the application, or in the alternative, establish that Strickland is the standard to govern ineffective assistance of counsel claims in the family court and hold that the Court of Appeals did not clearly err in this case. So I would respond to questions that the court have, or I would go on to some of the issues that were raised by appellant, whichever this court wishes.
Thank you. Let me see if people have questions, and then we can come back to anything else you want us to hear. Justice Viviano?
No questions.
Justice Bernstein?
Hi, good morning, counsel, and again, thank you. Good morning, and thank you again for joining us. So I have a few questions, and I very much appreciate your argument because I try to look at the law in kind of a similar fashion, which is, you know, the idea that you try to make the complicated simple and kind of apply common sense. But I want to, if I can, I want to kind of reverse your argument a little bit, right? Like, I understand the points that you're making about civil versus criminal, and I do understand what is governing this. But the question I have here is going along with your argument, you know, ultimately the defendant here is looking at jail time. I mean, at the end of the day, I understand the filing requirements are civil as it pertains to what you were indicating, but isn't it fair to say, based off of your argument, that the implications are in fact criminal in terms of incarceration isn't something that you would see as a civil issue. Having a record isn't something you'd see as a civil issue. And, you know, the potential issues and liabilities that come out of a conviction as it pertains to this instance wouldn't really be civil. It would be more criminal. Isn't it fair to look at it in that context and go to the other statutes that basically say that, you know, ultimate fairness is something that the court should consider if it deprives justice?
First of all, Your Honor, I would indicate that if we have a proceeding with a foot in both worlds, which is what Your Honor may be suggesting, we have to go, some aspects are civil, some aspects are criminal, then we have to go to the legislature to determine what the specific label is. And the legislature has determined that this is a non-criminal label. And the reason the legislature has labeled that is because it's overwhelmingly in juveniles' best interest that these proceedings be labeled as non-criminal. The goal of the family court is that juveniles will be rehabilitated, they will come out of the family court, not have a criminal record, and hopefully not offend against society and victims in general. And I see that you also may have a question about the fairness in this particular
right, because we can always go to the other statute that would allow for us to still be able to rule on this.
Right. Well, I think if there's a question between civil and criminal, and both
Correct.
This court's court rule labeling it as civil is consistent with the legislature's label of labeling it as non-criminal, I think that the label is properly not criminal, that it should be civil in this case. But, I don't know if I'm correctly categorizing Your Honor's question, is what, in this particular proceeding, why do you believe that it would be fair to the respondent?
You got it. No, you got it. And I appreciate your clarification. Yes. You got it. Yes. Just right in the nose.
And I would give about 3 reasons for that. And overwhelmingly, when the 42 days had passed, I was so relieved that I hopefully could call the victim's family and tell them finally that they had closure in this case. They had been with this case since 2014, had been at almost every proceeding, and I was hoping that I could finally give them closure. And secondly, of course, respondent believes that deadlines are important because she's suing trial counsel in part for missing deadlines. And third, this court always asks the litigants that come in front of them, well, counselor, this case is not just about your case, but it's about the cases that follow. And so overwhelmingly, if we ask the question, would it be beneficial for juveniles for the high court to come down and assert that these are in fact criminal proceedings? The answer would be uniformly no. And that doesn't mean this court can't change deadlines, though we've stated in our brief there's interest in expedition for juveniles. But we would ask that this court not label juvenile proceedings as criminal because that's uniformly not in their best interest. I know Your Honor is probably familiar with the ban the box movement, is when people believe that if you can say you have a criminal conviction, this is a lot of stigma to them. And in this case, with juveniles, the whole point of juveniles is that we don't give them the stigma. And I would just cite In re Galt, because I think that's really captures what we're talking about in this case. The in re Galt, the U.S. Supreme Court said, further, we are told that one of the important benefits of the special juvenile court proceedings is they avoid classifying the juvenile as a criminal. The juvenile offender is now classified as a delinquent. There is, of course, no reason why this should not continue, and that's our position in this case.
So, counsel, let me just turn then to the ineffective assistance argument and component here.
Sure.
And if you could kind of respond to this, I mean, you know, in terms of the standard that we're trying to apply, doesn't this entire case come down to credibility? And ultimately, I mean, literally, this is an example of, like, as what sister counsel indicated, based on what the judge's comments were, you know, the indication was that the individual convicted themselves based off of their credibility. And I guess my question is that if you have a case where it comes down to credibility, if you have a case that's factually specific like this one as it pertains to the use of the phone, isn't it just basic standard practice that if this is the crux and the fundamental element of your case, that you would do the minimal effort of getting the phone records from AT&T? I mean, my you know, relying on a screenshot versus basically getting the records, you know, to me, and again, I don't like to be overly critical of folks, but my question to you is, how is that not just standard basic practice that the attorney should evoke when this is the entire crux and essence of the defense?
I have a couple of responses to that. First of all, it'd be one thing if counsel did nothing when he was told late in the proceeding that there may have been this phone call, but that's not what he did. He asked respondent's mother, who was the record holder, to obtain the records. So the mother of the respondent came forward to respondent's counsel and showed records, and the records did not support the claim that there was this phone call from the victim's phone to respondent's mother's phone.
But it was it wasn't, but that's right, but that was a screenshot. It wasn't the actual records from AT&T.
No, and I would submit to you that what Dan Randazzo testified is that late in the proceeding, he told respondent's mother to go get records, and she showed him records, and she said later it must have been from he didn't know there was two phones being used, and he showed him the wrong records. Reasonably, that was the Verizon records. The Verizon records were from her business phone, and it showed in the Verizon records that she was in fact communicating with her son around the time of the incident, but it didn't show any calls from the victim's phone call into respondent's mother's call. Now, what respondent's mother testified is that she gave these screenshots with the AT&T records at the inception of the investigation, except at the beginning of the representation. But what Ryan Dobson, the attorney who met with them at the beginning of the representation, testified, she did not give these screenshots. So there was a credibility question which the judge resolved. And the judge said that Mrs. Ross was completely incredible about what the information that she said she gave to the attorneys.
Because I guess my last question is just, I totally hear what you're saying, and I totally appreciate your argument. I guess what I'm saying is, I get it. Like, I understand there was some confusion and you had different records, but I guess the question is, isn't it just straightforward? You just go to the company, get the records, especially if that's part of your case, and that's what you're going to, you know, it's a fundamental component. You know, there's like a one-stop shop. You go to the company, you figure out exactly what the call said, and it's a relatively straightforward thing to do, especially when the stakes are so high because so much is going to hinge on it.
Well, but the testimony was from Mr. Randazzo is that he got the records from the record holder and that she could download them from her account. So it's easy for her to see it. And the thing is, she was invested in this proceeding. So it's not like some Joe Blow off the street that says, oh, okay, I go get the records and here they are. She was invested in getting her son off. So
okay, so just so I understand your argument is that he was entitled to stop at that point and not have to go on to get it from the company, rather than he could rely on the representation that was made to him.
Right. He testified specifically at the proceeding that why would he subpoena them if he's seen them and they just don't reveal what they said? And I would just.
And you would then basically disagree with my contention that you should just go and get the records to start with, because it's so much is relying on it that you might as well just go and get those and then rely off of the records to basically create your case or understand the facts of your case.
And trial counsel also testified during the hearing. There's other reasons why he didn't go down that line of investigation. First of all, he was skeptical. He received these records, they didn't support what they said, and he was skeptical of information that the Rosses had provided because they had not been, they had not come through with other information in the past. For instance, both the mother and respondent gave written statements early in the proceeding that talked about what happened that day, and neither of them mentioned the phone call. And so, in respondent, he gave a lengthy interview with the police, and he didn't mention using this phone call. So Attorney Randazzo said he was somewhat skeptical that he heard about this late in the proceeding. And then he received other information. He said respondents and his mother said that the victim had sent a sexually charged video that he had downloaded on his phone. So when he got the download back, the download revealed, no, this didn't occur. In fact, there were hundreds of pornographic videos or photographs on his phone, none of the victim. He was sexting with other girls, not the victim. Her name was not even saved as a contact in his phone. So he was reason to be skeptical of some of the information that these individuals were providing. They also said that the victim had recanted. That turned out not to be true. And he also testified at the hearing why he believed this wasn't a critical issue, that this was a secondary issue. Second, he testified that the victim.
I think I understand your argument. No, thank you very much, and I appreciate your arguments. Thank you.
Thank you.
Justice Clement?
No questions. Thank you.
Justice Kavanaugh?
No questions.
Justice Markman?
So I recall you referring several moments ago to the concept of a mere error correction. Can you just restate what the significance of that characterization was in this case?
Right. If the question is mere error correcting, this court has to review under MCR 3.7.305 where there was clear error and occurred and there was a manifest injustice. And here, if we review the Court of Appeals conclusion, respondent has failed to show that they clearly erred in their determination. And these are not issues of jurisprudential significance if the Court of Appeals was correct in their conclusion.
So your principal argument is that there was no error here, not if there was error, it wasn't a particularly consequential error. Is that fair to say? That's
correct. And I would really, the linchpin, I think, of our argument is the standard stated by Strickland. And when a defendant has given counsel reason to believe pursuing certain investigations would be fruitless, counsel's failure to pursue those investigations may not be later challenged as unreasonable. And that's our position, that in this case, trial counsel had been given reason not to further pursue this line of investigation, and he reasonably went and pursued other lines of investigation.
You would not resist, though, the proposition or the premise that if there was a mere error or an error of any other sort that had lifelong consequences for a juvenile in terms of his adjudication as a delinquent, that would be a fairly significant error that this court might want to take very, very seriously indeed. Is that fair to say?
If your question is if the Court of Appeal, the standard, if there was clear error and it resulted in a miscarriage of justice, I think this court's standard is that it would review the issue. I don't know if I correctly answered your question.
No, that's clear enough. Thank you, counsel.
But I would note that I would disagree with Sister Counsel that the court, the issue of prejudice was absolutely resolved by the court's second opinion, because a month after the verdict, the court, when posed with the same issue, whether this issue regarding the phone records would have changed the result, the court said no. So we have two diametrically opposite conclusions by the judge. And so this court would do a de novo review, and for reasons that Justice Clement was referencing earlier, we would submit that on the issue of prejudice, the court's first conclusion in July of 2015 was supported by the record and not the second.
Thank you again.
Justice Zara?
No questions, thank you.
Counsel, I have one question. If we disagree with you about whether Mr. Ross has a winning ineffective assistance of counsel claim, but we agree with you that the filing deadline was governed by the civil rules, does he not have a winning ineffective assistance of appellate counsel claim, like a per se winning one?
Well, there's no motions for post-conviction relief in the family court.
He's insulated from bringing a winning constitutional claim because our rules don't provide one? Doesn't the Constitution trump our rules?
Well, I mean, this court establishes deadlines for a purpose. And in any situation, any litigant could believe that they have a winning claim, but if they file late, this court has stated that it will not consider the litigant's claims. And there's an interest in finality. And as I referenced earlier, the victims also have a constitutional right to prompt disposition. And so in this case, that's what we would submit. If respondent did not timely file, then he should not receive relief. Now, I would note that the remedy.
Let me interrupt you for a second. I'm not sure. I probably wasn't very clear. What I was saying was just go with me on a hypothetical. If we hypothetically believe that he has a winning ineffective assistance claim, a winning Sixth Amendment claim, a claim for which he should get relief, but blew the filing deadline because we believe the civil rules apply, doesn't he, as a matter of law, have a winning ineffective appellate assistance of counsel claim? And if so, are we allowed to do away with the Constitution in that context by our rules?
I would think in any circumstance, that would be true in any circumstance where a litigant would make that same claim when they file untimely. Say you have a convicted first-degree murderer.
And there's lots of law that says that the procedural rules give way to the Constitution. I mean, the U.S. Supreme Court has said that many times, and of course that would have to be the rule, right?
But this is a jurisdictional defect.
Okay, I think I understand you. Thank you very much, counsel.
And I would finally note, though, even though there's no post-conviction relief in the family court, the remedy for juveniles is expungement.
Okay, thank you very much. Thank you, counsel. Ms. Long, you have some rebuttal time?
Thank you very much, Chief Justice. I will briefly address in rebuttal specifically the issue as it relates to the filing deadlines. Again, I would ask the court to consider the appellate sections amicus brief in support, which clearly takes a different position than that of the Oakland County Prosecutor's Office, that says that when faced with the binary choice between criminal and civil, this matter does defy easy categorization, and that if there is any ambiguity, it should inure to the benefit of Mr. Ross and not his detriment. But I would turn my attention, I'd ask the court to turn its attention to the conversation as it relates to Mr. Randazzo and what the Oakland County Prosecutor's Office thinks was the point at which he could abandon relying on the representations of his 15 and 16-year-old client and his mother. And the fact of the matter is, Mr. Randazzo resigned himself to a trial strategy of simply saying what she said isn't true, rather than taking the step, which is what we were trying to put before the court with our request for an expert, It's not about saying what she said isn't true. It's by demonstrating that the other things that she testified to were not true. Those are matters that can be properly impeached. For example, by building a deadline, by demonstrating the fact that there was this Ariel Crooms character who was not, as her statement laid out, from the basis, the face of the statement itself, it did not appear particularly helpful. But if you spoke with Ms. Crooms, as we did at the trial level, then you would know that Ms. Crooms was with the complainant both before and after the alleged assault. If you spoke with Trevor Muir, not that his information, not that he had any eyewitness information, the information that was important from Trevor Muir is that Christopher Ross was not lurking in a hallway searching out a victim in this young woman. It goes contrary to the allegations, those two stark pictures that were painted, one by the complainant and one by the defendant. There were very few areas of gray. This was either a forcible, violent assault that ended when she struck him and ran away, or it was a consensual encounter that casually ended with borrowing of a phone call and seeing her later. As it turns out, it was the latter that was the case. We were talking about an individual, there was a witness before and after the assault. We were talking about an individual who was with Christopher Ross prior to the assault, and we know the timeline because the prosecutor's own exhibit had a timestamp of 3:59 on it. So if you take the time and do the legwork as defense counsel to discharge your responsibility to your client, to investigate those claims, to assemble those witnesses, to assemble that timeline that shows that there is no way that the complainant could have elbowed him and then run away home to shower, which is a very compelling version of events. The fact of the matter was she didn't. Even at trial, Mr. Randazzo was able to elicit from the complainant that despite the fact she testified she struck him and ran away, that no, in fact, she did recall seeing him later as he returned back with his mother to deliver Taco Bell to his sisters who were at cheerleading practice. Mr. Randazzo, having failed to interview the witnesses, having failed to secure the timeline, having failed to build it, didn't understand in the heat of trial the significance of that testimony. It rendered the timeline as offered by the prosecution in their theory, it rendered it impossible. And that is the issue that goes to credibility. Because if she didn't strike him and run away, as she very compellingly testified, then perhaps, just perhaps, that's where the trier of fact starts looking at the credibility of the respondent in this case, looking at the credibility of the evidence that supports his contention as opposed to hers. And in this particular case, the evidence bore out that he was correct. So this is not just a situation where, as Ms. Walton suggests to the court, Mr. Randazzo had reason to distrust his client or his mother because as a mother, what mother is not going to do everything that she can? She hired an attorney who promised her he was going to get an investigator. He was going to subpoena those sexting records. He was going to do all of the legwork that was going to be necessary to protect her son from a charge that, as it turns out, was wrongly levied against him. He did none of those things. And to say that as a result of his mother's inability to produce a record that he could have easily subpoenaed, it is to lay the investigative and ethical responsibilities of a defense attorney at the feet of his client's mother.
Thank you, Ms. Long. Are there any additional questions for Ms. Long?
Yeah, I'd just like to ask a question, if I might, please. Ms. Long?
Yes, Justice.
I'm just a little confused. Can you just briefly summarize for me, again, how you would, if you were writing the kind of opinion you'd like to see this court write, one correcting what you perceive to be the injustice here, how do we write that opinion again?
Justice, I would suggest that there are two factors at play here. First, the court asked 4 questions of myself and of the amicus. And one of those important questions is as it related to filing deadlines. And I think that the opinion needs to make very clear what those filing deadlines are in these circumstances, because I do not agree that at the time that that decision was made, that it was a simple and clean decision where this is a blown deadline. I do not believe that it's supported by the amicus as well as the facts in this case. But as it relates to the injustice that's here, it is a manifest injustice.
Can I interrupt you for 1 second, please, counsels? But if we believe to the contrary concerning what you call the blown deadline, is there anything that you would urge as an alternative approach to resolving this case in what you believe is the proper way?
I would, and that would be that the significance of the injustice is so significant that the court should still rule in favor of Christopher Ross on the substance because of the ambiguity of the deadline rule and because the significance of the injustice, because this is a case where either the trier of fact is accurate and there was ineffective assistance of counsel.
But the premise of my question was that we disagree with you on the blown deadline analysis. Now you're talking about some standard by which we're supposed to assess more serious injustices and less serious injustices. How does that come into play in terms of the kind of, legal premises that we're to apply in this context?
I think in answer to one of the questions, and I'll answer your question by responding to something that you posed of sister counsel, that there is an injustice here, and I do not believe that even if the court were to find that my office failed to file in a timely manner, that the injustice that is so significant here is something that is reviewable by this court. And that
I'm sorry to interrupt you, but is it your view, as the Chief Justice suggested, that if this error was of constitutional dimension in some way, then it can trump the, again, what you call the blown deadline?
It is, Your Honor.
Are there any additional questions for Ms. Long? Thank you very much, counsel. The case will be submitted. Thank you both.